Hello, everyone. Pleased to introduce to you Ms. Farida Al-Layan. She will be giving us the intellectual property rights webinar, and she will be discussing all of her knowledge, and she will be sharing it as well with you through this webinar, so you can all be enlightened and have a more clearer idea about intellectual property in pharma and in the healthcare industry. Ms. Farida, please go ahead.
Okay, Assalamu alaikum warahmatullahi wabarakatuh. Good afternoon, everyone. I'm Farida Al-Layan, Intellectual Property and Regulatory Affair Consultant for pharmaceutical industry and for intellectual property policies, strategies, and laws updates. We are discussing today, going through the intellectual property rights, an overview of intellectual property rights in pharmaceutical industry. The main topics we are going through it's a general introduction to intellectual property rights, patent law as a public contract, intellectual property in the pharmaceutical industry, the intersection of intellectual property and competition policy in the pharmaceutical industry, regulatory and competition perspective, impact of IP laws and its updates on regional healthcare, career opportunities for pharmacists and professionals in pharmaceutical industry specializing in intellectual property law. Intellectual property law, the definition of intellectual property rights, it's the rights given to persons over the creations of their minds. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. Mainly, it's to exclude others from using or exploiting or get benefits from this creation of mine for a limited period of time. Intellectual property rights are mainly divided into two main areas: copyrights and rights related to copyrights, related rights. Also, the second type is industrial properties. As a definition for the copyrights and the rights, we will go a little bit into the definition of copyrights and the main rights under copyrights. The rights of author of literary and artistic works, such as books and other writing, musical compositions, painting, sculpture, computer programs, and films. Usually, copyrights protected for a minimum period of 50 years after the death of author. Main two types, there is two types of rights under copyrights. It's the economic rights, which allow the writer the rights owner or the author to derive financial rewards from the use of their works by others. The other kind is moral rights, which protect the non-economic interests of author. For example, mentioning the name of author whenever mentioning whenever listing the artistic work or mentioning or having a quotation from this artistic work. Under industrial property, we have 5 types of rights. The first one is trademarks. A trademark is a sign capable of distinguishing the goods or services of one enterprise from those of other enterprises. Trademarks date back to ancient times when artisans used to put their signature or mark on their products. The second type is geographical indications and appellations of origin are signs used on goods that have a specific geographical origin and possesses qualities, a reputation, or characteristics that are essentially attributable to that place of origin. Most commonly, geographical indication includes the name of the place of origin of the goods, The most one from the most famous examples, Swiss watches, Parmesan cheese. This is both when you find it on the cheese or the Swiss, it is a geographical indication. The third type is patent, which is the most important right, IPR, or industrial property type for pharmaceutical industry. The patent or a patent is an exclusive right granted for an invention. A patent provides the patent owner, the patentee, with the right to decide how or whether the invention can be used by others. In exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. The fourth type, it's industrial designs. An industrial design constitutes of ornamental or aesthetic aspect of an article. A design may consist of three-dimensional features, such as the shape or surface of an article, or of two-dimensional features, such as patterns, lines, or colors. Trade secrets, the final type of the industrial property, and in my opinion, it's all or none, and it's the hardest to keep. Trade secrets are IP rights on confidential information, which may be sold or licensed. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of the trade secret protection. Also, the mostly used example for IP rights in one product. This is a Coca-Cola bottle. The Coca-Cola bottle was patented on 1915. So the patent is for the bottle. A trade secret is the recipe for the Coca-Cola. Trademark is this figurative shape of the Coca-Cola, the colors, the colors and the figurative writing of Coca-Cola. The registered design, the design of the bottle, the aesthetic design, also the copyright, the logo of the logo and how it's designed. It's considered artistic work. This is the IP in the bottle of Coca-Cola. Are we having messages? Can you hear me, everyone?
Yes, everyone can hear you properly, Dr. Farida.
Okay.
I think there is one question. I think Ms. Shaima Al-Maliki, she was asking about what is industrial property and is it the economic right?
What is the industrial property? No. Once can we postpone the questions to the end?
Of course, yes, we can postpone the questions to the end, no problem.
Okay, the patent of bottle is already expired since the 1919. Okay, yes, it is expired. It's mentioned on the on the bottle, but this is as an example for IPRs in one product. It's not. It doesn't mean that it's still valid until now, and we can answer. Okay, we will take also Shaima question, and we can postpone the question until the end, please. What is the industrial property? There are two types of intellectual property and of the IPRs. One is related to artistic work, and one of industrial properties. It's patent, it's related to manufacturing, compounds, products, not artistic works. And the economic rights, it's the rights of exploiting or to commercialize the product, to get economic benefits out of the IPR. Is that clear? If you have a question, maybe another one, you can please send it when we reach Q&A session, please. Thank you. Patent law as a public contract. We can say that the patent law is a public contract. I'm having quotes from this quote for Abraham Lincoln. The patent system added the fuel of interest to the fire of genius. Incentives matter for innovation ecosystems. They consider the patent as an incentive for the innovation ecosystem. If we did not have, this is for Fritz Machlup, if we did not have a patent system, it would be irresponsible on the basis of our present knowledge of its economic consequences to recommend instituting one. But since we have had a patent system for a long time, it would be irresponsible on the basis of our present knowledge to recommend abolishing it. But the patent system imposes cost. This is the major theme of IP. The major theme of IP and IP laws is to create the balance between incentives and access, proper balance. The problem introduced for incentive mechanisms is how to make sure that earlier innovators are compensated for the contributions while ensuring that the later innovator also have an incentive to invest. Okay, the economic theories of patent law or behind the patent law. The patent system is considered as an incentive to create, incentive to disclose, and incentive to commercialize. So when people can file their patents and make sure by patent they can hold their rights to exclude other from using their invention, so this is an incentive to keep innovation and also to disclose the invention, so to keep the wheel of innovation going and not to start from all over, and the incentive to commercialize, to take the benefits of this exclusive right for the patented product or patented innovation. And what's the difference between invention and patent? A patent is an exclusive right granted for an invention. So the invention is basically protected by the patent, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. So this is basically the contract between the innovator and the community to give me exclusive rights for my invention, And I will disclose the innovator will disclose to the public all the technical information regarding the invention. Okay, I thought this is this message for me. So what is patent? This is a patent, the first page of patent document for pizza box. The patent, it's derived from the letter patentis, means open letters. No such thing as common law patent rights. Rather, a patent is a government issued grant conferring the right to exclude others from making, using, selling, offering for sale the claimed invention throughout. This is the definition of patent in US, but I liked it because it's really clear. A patent does not give its owner a right to use the claim invention, and this is important in our industry. Granted patent for a new chemical entity does not mean that that we can. 1 second. Sorry for that, I missed. Okay. So a granted patent, we were saying that a granted patent doesn't mean that you have the right to use this invention. This is very important in pharmaceutical industry. Granted patent doesn't mean that you have an MAH approval from the health authority. Important questions and answers regarding the patent law. What kind of protection does a patent offer? In principle, the patent owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention. In other words, patent protection means that the invention cannot be commercially made, used, distributed, imported, or sold by others without a patent owner's consent. Of course, in each jurisdiction there is an exceptions for this. For example, Bolar exemption give an exception to where it is applied, give an exception to research and development entities to import or use patented active ingredients or patented molecules in research and development process. For example, for generics company, it can be used, or for any other research and development and other industry. Is a patent valid in every country? Patents are territorial rights. In general, the exclusive rights are only applicable in the country or region in which a patent has been filed and granted in accordance with the law of that country or region. How long does a patent last? The protection is granted for a limited period, generally 20 years from the filing date of the application. Intellectual property in the pharmaceutical industry. I'm I will be talking on the IPRs on these three processes or core aspects or core processes in the pharmaceutical industry. The development of a new drug, new discovery, new drug, a new molecular entity in new biological medicine, the new drug approval, generic drugs and biosimilars approval. This is a research and development phases scheme going parallel with patent timelines. This is from EP, the European system. So you are basically saying, see, from zero day of patent application to 25 years. These 5 years we will talk about later. It's by maximum 5 years as an incentive. It's a supplementary protection certificate for pharmaceutical products as a compensation for the long regulatory process, and it's specific for EU, for European, for the European, for the EU. This can you see that? Okay. For the development of the research and development process of a new chemical entity, they are using 10,000 molecules for this. They are starting the patent application. This is on 0 day. And as you see, there are 10 years of research and development. And after 10 years, while the patent is filed, it's different when it will be from jurisdiction to jurisdiction, where it will be granted, when it will be granted. So the regulatory process is going parallel to the patent. So as the protection is going from the day one of filing, the regulatory, the research and development process is eating from the protection, the exclusivity or marketing exclusivity that patent is giving to patentee or the IPR owner. So it takes 10 years for research and development, and then 2 to 3 years for administrative procedures, cover the pharmacovigilance, the registration, before also all phases of clinical and pre-clinical development and clinical trials. After this, so the years they are exploiting the benefits of this exclusive right, it's on average 8 years. The pharmaceutical industry, different perspective. There is different perspective regarding the IP rights and the innovative product or generics products in the pharmaceutical industry. So originator see that the intellectual property, like as patent and regulatory data exclusivity, encourage and protect innovation and provide the needed incentive that drive R&D investments to areas of unmet medical need. An effective IP system gives innovators increased legal certainty that if a medicine makes it to the market, it will be protected from unfair competition for a limited time. So generics also, they are always requesting for legal also certainty. So any legal certainty that they will not be sued if they are getting into the market and they are accusing originator of doing this what we call evergreening patent, patenting more than one patent and sequenced types of patent to prolong this exclusivity for them. Generics and biosimilar are advocating for better access of medicine, affordability of medicines, and lowering healthcare bill. So originator and generics are on opposite sides of this equation. Patents and patent information. Usually the originator is looking or doing search on patentability if the invention is patentable or not. And generics industry look in the disclosure of the patent documents to find opportunities. So there are two different perspectives. While we are looking for the patentabilities and the claims of the patent, what is really patented, we are also on the other side having the disclosure of the document, full technical document that give other people the incentive to build on this innovation process. While the patent and the protection is territorial, the disclosure of the patent document is global. You can find it anywhere because it's after the disclosure of the patent application and then the patent, it will be in the public domain. So anyone can use the information and build on it. And after the patent expired, they can exploiting any commercial activities. The patent is limited, but the disclosure is for the information. For the information and innovation process is permanent. The patentability is only for the claims, so it's the protection is exclusive to the claims, but the disclosure should be to the full document, the protected claims or aspects of the invention and all other supportive documents. So the patentability is exclusive rights, while the disclosure is a learning opportunity. So basically, as we said, the patent law it's like a contract between the inventor and the community. The inventor will invent, and let's say about let's take the pharmaceutical example, pharmaceutical industry as an example. The innovator, the inventor will do the investment in the research of and development of unmet medical needs, and the community will use it, and the inventor will have an exclusive rights for a limited period of time, and then the community will benefit from this invention, and then they can build on it and make the generics industry from it. What is patentability criteria under a TRIPS agreement? This is one of IP agreements, international IP agreements. So the invention to be patentable, to say that we can patent this invention, it should have the following criteria. The first one, novelty, if not available to the public prior to the original application date, the priority date, not prior art. The prior art, public lectures, earlier patent application, oral disclosure, written information. So it should be novel. If anyone is seeking to to patent an invention, they should not talk about the invention to anyone. If they are seeking a consultation, they should sign an NDA for maybe for the research, and the universities maybe they should not publish any paper before going to file the patent, because it will be all considered as a prior art, and it will be it will not considered as novel. The second criteria is inventive step. It should be non-obvious. Non-obviousness, the inventive step reflects a general patentability requirement in most patent law, according to which an invention should be sufficiently inventive, not obvious in the view of the prior art, using the skilled person's common general knowledge. For example, in the pharmaceutical industry, it should be a pharmacist with a certain criteria in order to be patented, or in order to be patented, or the patent to be held valid. The third one, industrial applicability, should be useful. Any invention that may be used or manufactured in any commercial activity, not purely experimental inventions or biotechnology research tool. Policy rationale, for example, new medical use. Of course, the application of each of these criteria, it's applied in each jurisdiction according to the law. For example, there's some exclusions from patentability. It may be due to moral or the law of the country. It could be having the following the three criteria, but not according to the law. It's not patentable. It is excluded. Is excluded to be held valid as a patent. For generics industry, patent search is mainly freedom to operate search. We can define the freedom to operate search as it's the ability, or freedom to operate. Freedom to operate is the ability to proceed with the research, development, and commercial production of a new product or process with a minimal risk of a new infringing or infringing the unlicensed intellectual property rights or tangible property of a third party. So in pharmaceutical industry, we have different perspective. The patentability, we are looking backwards, looking in the prior art, if anyone invent or publish this. In the freedom to operate, we are looking forward to for example, commercialize a generics version without infringing any valid patent, or to check that there is no valid patent to go forward with the development, or to develop an infringing version of medicine with a valid patent. We are going now through the type of pharmaceutical patents. There are different types of pharmaceutical patents. These examples are for non-biological pharmaceutical products. Single medicine may be covered by separate patents. For one, for example, for one new chemical entity, let's take sitagliptin as an example. We can have the chemical compound patent, active ingredient, sitagliptin by itself, or the base compound. polymorphic forms of the compound, salts, also salts and ester ethers, enantiomer metabolite, and other derivatives of compound. This is another patent, could be filed for single medicine. For example, single phosphate patent, sitagliptin, phosphate patent as a salt, formulation and composition of the compound, the formulation of sitagliptin 1 milligram or the tablet, different dosage forms. Different dosage forms also can be patented, capsule, tablets, oral solutions. One or more indication for the medicines, new indications, a combination of the compound with other active ingredients, also like sitagliptin, metformin, processes and methods for manufacturing for the active ingredient, polymorphic forms, derivative compounds, or the formulation and composition as a finished product. This a summary of main types of pharmaceutical patents. For biological medicines, medicinal products such as vaccines are also usually covered by more than one patent. Typically, there will be a separate patent covering the protein sequence or combination of proteins of a virus-like particle, followed by a subsequent patents covering compositions and formulation. The fourth topic we are talking about today is the intersection of intellectual property and competition policy in the pharmaceutical industry from regulatory and competition perspective. As you know, the patent or the IP laws came to protect innovator rights, but without giving the innovator the right to monopoly the market. So it should be a balance between patent and exclusivities. What is the difference between patents and exclusivities? We are talking about drug protection, data protection exclusivity, sorry for that, data protection exclusivity and market exclusivities. Patent and exclusivity work in a similar fashion. They are working for the same result basically, but are distinct from one another and governed by different statutes. Patents are property rights granted by the Patent Office anytime during the development of a drug and can encompass a wide range of claims. Exclusivity refers to certain delays and prohibition approval of a competitor drugs available under the statute that attach upon approval of a drug or a certain supplements. The period of exclusivities and patent terms may or may not run concurrently. Exclusivity was designed to promote a balance between new drug innovation and greater public access to drugs that result from generic drug competition. Examples of IP incentives framework for the originator, data exclusivity, regulatory data protection, supplementary protection certificates. This is applicable, the supplementary protection certificates in Europe, in EU. It's basically it's like extending for the exclusivity or patent exclusivity rights for the registered product it have certain conditions to be applicable, and it will be from the regulatory authority. Also, other type of exclusivity as an incentive for the inventors. There are two types of RA exclusivity. It's the pediatric extension or pediatric exclusivity, medicines for children under the pediatric investigation plans. If the innovator invest in the research and development for the pediatric dosage for the pediatric investigation plans, they will have pediatric exclusivity, usually 6 months, and it is different from a place to a place, and it's also not applicable in all jurisdictions. Orphan medicines are for rare diseases. The rare diseases is defined by the EU as any disease which affects fewer than 5 people in 10,000 people. These exclusivities are really important for the communities and unmet medical needs. Because I believe that these incentives keep these exclusivity play a good as a good incentive role for the research of development for the pediatric medication and for orphan medicines. The impact of IP law and its updates on the regional healthcare. Mainly the recent, I will start with updates related to the IP and data protection, also IP related to RA in our region. First of all, it's Saudi Arabia Intellectual Property Authority. There is the updates of SFDA patent linkage updates, GCC patent law updates, UAE patent law updates, Kuwait patent linkage update. I'm really proud of the progress and for the Saudi, as you know, in the before 5 years, I guess it's 5 years or more, in the Kingdom of Saudi Arabia, this a separate institution for the IP, governmental institution for the IP, established. It's the Saudi Arabia Intellectual Property Authority, and I'm really proud that recently they we have read that the unanimous approval was granted for Saudi Intellectual Property Authority to become an international search authority and international preliminary examination authority. So this is really one big, huge step in on the IPR situation in our area. On the other aspect regarding the patent linkage, the SFDA issued a new regulation for the submission of a human drug that requires an authorized FTO report for the submission for certain files, or also the draft for the patent linkage process. Other updates in our region, the GCC Patent Office ceased to accept new patent filings for GCC patent applications as of 6th of January in 2021, but we are happy to hear that the GCC Patent Office resumed receiving patent applications on behalf of Kingdom of Bahrain and State of the Kuwait, examining the formally and substantively patents application on behalf of them starting from January this year. Also, the UAE updated its law on industrial property through Federal Law number 11/2021, and the patent linkage procedure in regulatory affairs. Also, the published ministerial decree in 2021. It also includes patent linkage process. And what's the impact of this IP updates on our healthcare system in our region? The impact of IP, if we have the right balance between innovation and the competition or unfair competition, if we are respecting the IPR of a third party, or it will be an incentive for innovation and big investment inside our region. Also, taking care of business or innovation incubator, it will be an incentive for transforming the research for small projects or the research in the universities to an invention and to be as an invention and then as a patent to be economically exploited for the benefit of our region. The impact of IP updates we are hearing lately is the patent linkage, which is basically it's a process of linking the patents or approved patents to the process of the marketing authorization approval in the pharmaceutical industry. And this also affects the market access. If it's clear or not clear, it may be delay or make open the door for generics to access the market. It will affect also the medicine affordability to have the innovative product and generic product if the region respecting the IPR and there is a balance between respecting IPR and preventing any unfair competition or monopoly. This will affect medicine affordability. And by the end, this is all going to reduce the healthcare bill and to direct us to research and development and to innovate and patent our inventions. So the balance out between innovation and affordability offers drug developers some protection while facilitating and giving incentives for companies to file generic drugs, offer incentives for drug manufacturing companies for R&D of innovative medicines, offer affordability by developing a path for generic drug developers to bring pharmaceutical to market at lower cost. Shall we go with career opportunities? Okay, so Rasha, I will answer your question after finishing these slides related to career opportunities, and I will send you up something to read about it, inshallah. Career opportunities for pharmacists and pharmaceutical industry professionals specializing in intellectual property law. As I see, as you heard from me, there is the past few years showed updates in IP laws, IP strategies, not only in pharmaceutical industry. It's also in the innovation sector, in all other aspects of the economy of our region. So we need a better understanding of intellectual property law to have in any place we are work in a balance between innovation and not to infringe or exploit any other party exclusive rights. So to respect and innovate, to have this balance, we need more understanding of the IPRs. From what I seen in the few past years, the career opportunities for pharmacists or pharmaceutical industry professionals from any background working in pharmaceutical industry, chemists, chemical engineers, biotechnology, pharmaceutical industrial engineering. This is only as an example. Career opportunities, law firms working with originator in the section of prosecutions of the patent, filing the patent, following the patent portfolio worldwide. They need sometimes someone worked as a pharmacist with a background as a study or a profession, the pharmaceutical industry, to work with them to combine between the IP and the technical part of the pharmaceutical industry or pharmaceutical knowledge. The IP department, generics manufacturers, we are seeing lately a lot of more than one company establishing an IP function or IP department, or investing in one person to know more, to be knowledgeable more about the IP, to be responsible for the IP issues. Also, the IP department for originator or innovative company. We call it also patent analytics. Patent analytics, this is, I can see it in data intelligence companies, patent information databases. They need someone to understand. Someone can read the patent and understand the patent law. Also, patent law, patent process. Also understand the technical or the pharmaceutical industry language, the pharmacy language, the chemistry language. So having a background of as a pharmacist or any other professional experience in pharmaceutical industry, this makes a very good experience to handle these opportunities, these vacancies. Also in patent drafting, this is mainly in innovation incubator or business incubators, in originator research and development centers. You need to understand the language of the pharmaceutical or professional language, and also the IP or law language. In R&D and research and development, it's either in it's maybe in originator or generics. And as I'm coming from generics background for the past 15 years, R&D people needs to be expert in reading patents, how to search for patent, how to know what is protected, is it the claims, is the description, and the patent information for the search and innovation. It is really it's really a treasure, and you can find many opportunities for developing non-infringing formula. For example, IP consultation. You can do IP consultation for companies doing establishing IP functions with economy ministries, or for example, Ministry of Trade, in which any patent offices or trademark offices or copyrights under these institutions, governmental institution. There is a lot of consultation related to the updating of IP strategies and policies these days. In business development, also business development department, IP knowledge is really an adding value to help the business development function with choosing the molecule in pipelines, or what to develop, when to launch, support the RA department when you can submit for registration in case of patent linkage law process applied. 1 second. Okay. Also, technology transfer offices in universities to give consultation guidance for TT offices to transform the research and inventions to an economical value through patents. Also patent and trademarks offices, governmental ones, also innovation incubators, the same support you give to people in the technology transfer offices, in TT offices in university. It can be for innovation incubators. These are separate institutes of other than the universities. Okay, as we went through the career opportunities, I'm seeing, I can see that it's the vacancies of IP are increasing. It is still limited, to be honest, but from the accelerated and booming IP status IPRs in our region, I see that many career opportunities will be opened, will be available to better understanding. It will be needed in pharmaceutical industry and also other industries. And that's it for today. Thank you for listening. Let me take 1 minute. I want to announce that PRA is launching the intellectual property rights in the pharmaceutical industry. A training course, comprehensive course. It will be online starting from 15th of October this year. For more information, please call contact or call training department, and here you can find the email. And maybe Rika or Rabi', you can send the brochure for the audience of the training course, please, and the email of the training at PR, please. Thank you everyone for listening. We can have the questions. Okay, Muhammad Al-Nadi, how can we check the patency status if we are to register a generic products, and will the process differ between first generic and second, third, or further generic, and how is it be submitted in the CTD? I have it's different from each jurisdiction. Kuwait is requesting for Kuwait is requesting for a letter. According you need to submit a legalized FTO for NSFDA, but it is a process for generics. We call it, it's an FTO process, a freedom to operate search. You need to do this process. Usually, you can do it through public sites or databases or private databases. And yes, it is check the patency status if we so you need to cover for example, for GCC, if you want to submit in one of GCC countries, you have to check the GCC patents, and if you are going to submit, for example, in Saudi Arabia, you need to check Saudi patents also, check if it's valid, and it is a process. I will there is a process published by the SFDA, and I will share with you, inshallah, the latest published FTO regulation. Mustafa Makhlouf, I'm afraid that we can't cover this. Could you please explain UAE patency laws in light of both 2022 laws? If you can send me an email, and I will send you both, and a summary for the differences, Mustafa. Honestly, we need to. It needs time to answer this question now, and we are approximately out of time. So please send me or for PRA email. I would write you my email. I will send to all of you my email. You can. Ali, please send me your question, or send it to PRA, and I will send you both laws and the main differences between. Okay, can you please, this is from Subhashri Sahani. Am I saying this? Okay. She's us, she or he, I don't know. Can you please explain in details from GCC Patent Office and UAE, how can we dig out further patent details? Or for the GCC Patent Office, you can find the legal status on the website. You can write the number of patent or patent application, and you can see if it's granted as a patent or still an application. For UAE, I'm afraid it's a little bit complicated to know the status. You mean by valid or lapsed or it's a still application? This is, I guess, what you mean. Also, there is always the option of going for a private or paid databases. For paid databases, they provide such information. Mubarak Ali, okay. This is for everyone. Any questions? Okay, we have from Russia. Could you answer my questions? Okay. Okay. If the patent is registered in any TRIP country, does it need to be registered again in UAE IP office? It's the patent is territorial, so filing or filing a patent or granting a patent in any country doesn't mean that it's granted or valid in UAE IP office. Yes, it should be filed and granted in IP in the UAE IP office. Yes. I have a generic product registered as trademark in country of origin in Europe. In country of origin in Europe, do I have to register this trademark again in UAE IP office or no need? Actually, it needs more details to know more details. And to protect your trademark, usually you have to register it in the UAE IP office, but I need more details. This is a very generic question. Okay, Rasha, dear, could you answer? Okay, Rasha Ali, do you have any other questions? Okay, you can email me or contact me for any other questions. Irshad Moulani, do generic company needs to submit a patent certification or a declaration while filing generic drug application? This depends on the on the country requirements, registration requirements, and yes, some countries ask for, some countries not. It depends on the patent linkage process and the updates of the regulations in the country you are submitting in. Does anyone have any other question? Okay, do generic companies. Yes, we answered. We answered. Any other questions, please? For any patent law documents or regulations, or if you need any of latest regulation updates or patent linkage updates, or announcement by GCC Patent Office, or if you need any help in this, please send me an email writing the country and the needed specifically, but not questions about specific products, unless it's okay to share details with me, to not go to with any infringing for any confidentiality or breaching of any confidentiality for any product. Any question, please? Thank you all. As we are, there is a raised hand. Hi, could you please mention? Okay. Yes, yes. So also, for any question about the intellectual property rights in pharmaceutical industry course, or if you would like to have more comprehensive information about the topics, we had patent search, FTO search. It will be all covered in the intellectual property rights in pharmaceutical industry training course PRA are offering. Please email PRA consultancy for more information. Thank you, everyone. I'm waiting for your questions through emails. And thank you, Rasha. Thank you. Please send me if you have any other question. Thank you all. Thank you. Thank you. Thank you for your time.
Thank you, everyone, for those who attended this introductory webinar. We are now going to close this webinar. And if you have any more IP queries, you can send us an email at training@pra-me.com, or you can contact us directly on WhatsApp. That's 056-298-8438. Or you can also email Dr. Farida for any other specific queries. Thank you so much for your time. Hope you have a great day, everyone.